Court calls the case of Pleasant Lake Park versus Christopher Janowitz.
Happy to see you, Judge. Happy to see you, Mr. Allen. I have documents to submit.
What? Oh, just
David Morse on behalf of Plaintiff Pleasant Lake Park, LLC.
thank you.
Thank you.
Your name, sir?
Christopher Janowiak.
Okay. And what documents are you trying to submit to the court?
A counterclaim.
Have you?
Judge.
So this is our fourth hearing. Last hearing, plaintiff presented an inspection, an unsworn statement by an inspector, and Mr. Janowiak asked for 1 week to get his own inspection done. I understand that he has done that. He provided me a copy of an inspection report today, just before the hearing, and I understand from the Register of Actions that he filed a motion to set aside default, which maybe is the counterclaim. I'm not sure.
I don't understand how I submitted money. I don't know if I did that. I don't understand how I submitted money. I don't think I did that correctly.
How you what?
The money that you ordered to put in escrow,
Yes.
it's like a holding. Like, you know, you may give me all the money back, hypothetically. I don't think I submitted the money correctly. Because I don't want to I put $12.30 in escrow because there's a $20 fee.
You did.
Why are they putting this over here?
I don't know. We also made him fill out this form. I don't know. That's why.
Oh, I see.
I told you about
Yes,
that.
you did. Okay.
Yeah, I think I did that.
No, the money, the escrow's there. We had a clerk that, I don't know why they did this. What they did, counsel, is apparently the only way that they ever saw escrow come in without an understanding that I ordered escrow was on a motion to set aside.
I see.
And so they had to fill out that form, which really means nothing because there is no judgment had they looked.
Yeah, I'm ignorant of my actions. I don't know.
No, it truly, sir, there may be other things that are your fault. This one's not. So, well, okay. You can hand it to me when I want you to hand it to me. You really do not have to bow. Okay. Have you seen the counter complaint?
No, I'm not aware of a filed counter complaint. And for the record, I haven't seen a copy of an answer, haven't seen any writings by the defendant.
Okay, so let me just back up a second. What did your report reveal?
It revealed conspiracy and perjury by the landlord, Mr. Weasel. And
Oh my gosh.
investigators.
No. You had an inspection.
Yes.
Or
the inspection determined that there is a complete infestation
of what?
of rats. A complete infestation. There's rodents everywhere. Throughout the home in areas like the rotary room and wide open, and you shouldn't see this is usually a sign of an infestation. The loose material underneath the dresser and behind the stove is from the rats trying to create a nest. The loose material behind the stove is from the stove's insulation and be very.
Who's this from?
It could be a fire hazard. This is from a company called Proof that has over 100 years. And I have colored photos and I have the license and insurance.
Okay. Just let me.
Would you like a copy?
Thank you.
Thank you.
I gave the kind lawyer a copy of this. Sorry. I don't know if that's that you give him what I gave you.
Yes.
Okay, so we have like that is what I have. So the technician comments are there are more pictures I did not.
Okay. Were these pictures a part of his report?
Yes, sir. Yes, sir. This is,
Okay.
I haven't slept a single night since August. I called the police twice because I thought there was people outside my house, but it's really just a rat infestation. I've tried to get resolved and they wouldn't do walkarounds. So since August, I haven't
called the police on the rats?
This is the rats, yes. There was more creatures the whole house was just, there was holes in the skirting and there's proof. There's holes in it underneath the cabinets are connected to the wall. It's a complete rat hotel. I go there every night. They chew my property. This is complete opposite of what this client said. His inspector is my next door neighbor. There's a conflict of interest in here. There's conspiracy. There's perjury. I might take this to trial to get them on record, so I can later sue them.
Okay.
I might take this
All
to
right.
get them on record.
Okay. All right.
I might. You're judge.
Well, we welcome any trial if you would like to file an answer and a counter complaint. Your Honor, frankly, this is the first that plaintiff is hearing of rats. And this whole case it's on non-payment. For weeks or maybe months, the defendant has been complaining of a beaver or a badger under his premises. My client has been taking steps like trapping, poison, inspection under the premises, outside of the premises. We filed a non-payment complaint, and the defendant still did not raise this issue. First hearing, second hearing.
Oh, trust me, counsel, I remember everything
Thank you, Judge.
on this, and I just. What's in your counterclaim?
My counterclaim, Judge, has a photo evidence of a complete rat infestation, the complete opposite of what.
Okay, but is that the counter complaint?
I mean, this is enough for his client to be convicted of perjury and conspiracy.
I don't know what that means. I'm just asking, is that your counter complaint?
Yes, Judge.
Can I see that? And counsel, I'll let you take a look. I'm trying to. Oh. Lord, we'll see. Here. It's the report.
Yeah, that's fine. Yeah, this just proves everything that he's been saying the whole time. Because this is a licensed and insured rodent pest control with over 100 years of experience. And his rodent and pest control man lives on the same property that Mr. Weasel owns, which is a conflict of interest. And he's not licensed or insured. The inspector doesn't even own his own vehicle. He lives with his kind elderly father. And he used this.
Sir, do you understand that
I don't understand.
is not, it's clear that is not a counter complaint.
Should I put it in writing?
Well, that's usually where it starts.
Okay,
Yeah.
I know there's an order of operations and proper, ways of operating here. I thought this was sufficient for the court, that this is a professional who's licensed and insured with multiple lines contradicting the plaintiff's claims. And I want to make a deal. I want to leave. I feel like I'm being attacked.
You want to go?
My deal is, my proposed deal is not a serious one. I do want to go, but
I don't know what that means.
yeah, I would like to hear a deal. I could propose a deal, but I mean, I really want to stay here and get this rats out of my bedroom. It's literally my bedroom. It's literally I have a stick just to poke the rats underneath the dresser. I literally have a rat stick next to my bed. For the record, I literally have a rat stick next to my bed for 5 months. So I can put this in writing. And I'm sorry to waste the court time. I've been trying to make a deal, but I tried to do a walk around and I tried to do a proper investigation months ago, but
Okay, sir.
yes.
There are certain ways that you would have to do an answer and a counter complaint. Okay? And you need paragraph by paragraph laying out your allegations as against the plaintiff, as well as answering the plaintiff's claims in this case. You follow me?
No, I don't understand. I thought I did that when I first did the paperwork for the contract, like, it says like, how do you respond to the claims? And I was like, yeah, I disagree with everything but like the money portion. So, I just thought this was like pretty cut and simple, like, if there's a fly in your steak, you're not gonna charge it for potatoes.
But sir, you started out with like a beaver or some large like badger type animal under there. Then when you came back the last time, we weren't talking rats. You were talking about mice and the baseboards being ground zero and all of that stuff.
Yeah.
Now I get here today and now these mice have grown and now they're rats.
Oh yeah, the problem's gotten way worse. I agree with you, Judge. Problem's way worse now.
You're not really saying the mice grew into rats.
I'm saying that the rats have been there the whole time and that we haven't done a proper inspection. Yep, proper since the beginning.
All right.
Sir, Judge.
Sir, go ahead.
It's plaintiff's position that to the extent this is a defense about habitability, that this is the tenant's willful and that the tenant has caused these through irresponsible conduct or lack of conduct. To the extent he has a rat stick or anything else, this is the first plaintiff is hearing of it. This should have been.
Heard of rat stick.
This is to the extent the landlord should have trapped, should have baited, should have taken any steps. We needed to have been made aware. We were not made aware. It's clear to me that defendant has taken no meaningful steps to resolve the issue. His living conditions invite the issue, and that we can't be in a position, the landlord cannot be in a position to check in on the defendant to ensure that his quality of life is where maybe it should be. I submit to the court that there is no tribal issue here. To the extent the court disagrees or believes that there should be another chance to file something in writing, I think this needs to go to a trial, a short trial.
I want a bench judgment.
I'm sorry?
I want a bench trial. Judge.
Well, that's all you're entitled to at this point because I don't have a jury fee. So
Correct.
So
one other point for the record, Your Honor, is that management understands that. So there have been attempts to go out for the beaver or badger, and there have been attempts to assist with skirting and other various issues raised over the months. Management has been responsive, but understands that there was at some point, defendant in the last month or so made a comment to a neighbor saying that he would shoot management if they came and knocked on his door. He also claims that management has stolen hamburger off of his counter. So we're not sure if these allegations or threats are real, and we have to assume that they are. And this is part of management's concern, is that, frankly, that the situation has broken down, and I think a trial would show that there were no attempts to bring management in on the rat, the mouse, or other issues other than the badger or beaver, and those have been proven or shown through the unsworn statement to be flatly false. Mr. Janowiak's inspector clearly did not see any signs of a badger or beaver either.
hey, so how long is it going to take for you to put your complaints in writing to the court?
I don't understand what I should put.
Well, you're going to need to understand.
Because I thought this was, so I know I'm not asking for legal advice.
Good,
But
I won't give it to you.
Right. So, and I this is quite the maze. And that's my ignorance. So I can put something in writing within 7 days, once I understand what to put, that's going to be acceptable to the
All
court.
right, you're going to need to get to figure it out in the next 2 days. Your defendant to file a written answer.
A written answer to what? A written answer
to the complaint.
To the complaint, and the complaint is what, Judge? I don't know. I don't understand what the complaint is.
All right. You got served with a complaint. That's what brought you here. You need to file an answer to that complaint. And if you got a complaint against the landlord, you need to file what's called a counter complaint or your complaint against him. That you keep trying to hand me is not a complaint. It is not a counter complaint. It is nothing for the court at this point.
I don't understand. So I will submit what so
You're to file a written answer and or counter complaint.
to the
You're to do that by December 3rd.
Yes, Judge.
Filing of that will only be complete once you file it with the court and you serve counsel with a copy,
I don't understand how to serve counsel. God.
usually by email.
I don't have proper access to email all the time. That's why there's like lack.
Okay, get a stamp, put it in an envelope and send it to him.
It's got to get it twice a year, basically. Judge.
No, you gotta, when you file it with the court, you have to serve them a copy because you have to acknowledge that you've given them a copy of what you're filing with the court. Then, so you're to do that by December 3rd. I will give you time to look at that. I'm going to go right to final settlement conference on it. And so I'm going to set a final settlement conference on this case, which is the step before we go to trial. Set that for December 9th, 2025 at 9 a.m. That is in person, and all parties must be present. Now, I'm going to let you know, I want you to understand this, sir. I have a lot of latitude if you don't follow the court's directions. So if you don't file an answer or a counter complaint, but if you don't submit something in writing in its proper form, I'm going to grant them possession. I'm going to grant them a judgment. I'm just going to let you know that.
I will submit a written response. Judge.
Is there anything else?
No, Judge.
I had great trepidation ask.
What trepidation?
Never mind.
Did you define that?
Never mind. No,
I don't understand what trepidation.
I'm saying I didn't really want to ask you if there's anything else because I didn't want to hear anything else. All right? Just to be blunt about that. But as a matter of courtesy, I have to make sure that everybody's been heard.
Yes, Judge.
Is there anything else?
No, Judge.
Sweet. Thank you. Everybody have a good holiday. Is this your only copy, counsel?
Yes, it is.
All right. So I'll. Court could stand in recess. I'll be right back. I swear.
All right.
Bye.
You may be seated. State of Michigan is now back in session. The Honorable Mr. Tibbs preside.
You may be seated. This one doesn't. Fixing housing 401k plan versus Erica Ward.
Good afternoon, Your Honor. Steve Otherly on behalf of Plaintiff Fixing Housing, 401k plan.
Good afternoon, Donna Toth, on behalf of Erica and Aaron Ward. They are the tenants in this lease.
All right. Where are we now, folks?
So my understanding is after the long conversation that we had last Monday, that this hearing was held in anticipation of my action or interaction. And I would, if I filed a withdrawal, then the hearing wouldn't be held. And
If you filed a I don't think I said that.
Well, you didn't say it, no. But you said that if circumstances worked out the way you were suggesting, there were two choices, and that's why this hearing was being held. Do I not have it correct?
I don't know what you have. Keep going.
Okay. So I'm here because I would like to make this statement to the court on the record. This case is a landlord-tenant case. I repeated that in our answer that was filed with this court. The lease is not a commercial lease. As plaintiffs and this mentioned several times, the lease is between an LLC landlord and a married couple, Erica and Aaron Ward. The lease specifically states the lease is for their use as an animal farm. The property is zoned agricultural and has been used lawfully for over 25 years as an equestrian center with several major outbuildings and one residential unit. This lease began in 2021, just 3.5 years ago. The lease terminates in 3.5 years from now. None of the land is zoned commercial. None of the property is used commercially.
Why are you telling me this now?
And the lease is not a commercial lease because several times plaintiff has referred to this as a commercial lease. And I heard this court repeat that this is a commercial lease. There are different standards applied to commercial property and commercial property that is leased.
All right, then all you have to do is say, without this long rendition, that you don't believe it to be a commercial lease.
Okay. Well, I felt I need to just restate what I had said in my answer. It didn't seem to have been heard. I have been associated with Erica Ward.
I hear everything. Now, whether I react to it becomes a whole different thing, but I hear everything. Go ahead.
Well, I have been associated with Erica Ward for over 3 years in consultation with me as a property manager through my solo-owned property management company. She consulted with me over these past couple of years over many serious, dangerous conditions the landlord had refused to repair. I gave her the City of Ann Arbor information required to be provided to tenants by landlords and the Michigan State University Law Center's information for tenants and landlords, both of which describe the right of the tenant to withhold rent and pay for necessary repairs for the health and safety and habitability of the rented property when the landlord has refused to make the necessary repairs. Our answer filed with this court had the circuit court case attached, which was filed in July 9th of 2025. The jurisdiction for our breach of lease case was with the circuit court. And our answer describes the necessary repairs the landlord refused to make since 2023, which is his duty under the terms of this lease for agriculturally zoned property.
You
Erica
can't
Ward.
have it both ways.
Hmm?
You can't have it both ways. If you're going to claim, and counsel, before you go on, I think you need to do your legal research. If you're going to claim that this is not a commercial lease,
Yes,
and it's a 7-year lease,
yes.
then the obligations regarding repair change.
That I think that would be something to bring up by the plaintiffs to rebut what I'm
No.
saying.
Go ahead.
Erica Ward asked me to be her attorney in the middle of July to file a complaint with the court over the landlord's waste and interference with her use of the property, which had caused her damages. This complaint was
Counsel,
filed
I don't know why I need to know all of this.
because, Your Honor, you have questioned my ethical ability
I
to
have not
represent.
requested, I have not. What I have said is that if indeed you took funds that were the landlord's funds, the capacity that you're operating in is going to be a problem, council. That is what I indicated. If you don't see it as a problem, then so be it. But I think on its face, it's a problem. Any question regarding your ethics is your own. Because I'll tell you right now, if an attorney comes before me and I think that they have done something that I can show that they have done unethical, you will be reported to the Attorney Grievance Commission in a minute. So I did not do that.
No,
So
you-
don't tell me I question your ethics. I question the question. You know what? I don't need the dramatics. Any more dramatics, you're gonna be found in contempt. I'm done, Ms. Tope.
Yes. Yes.
What I said to you and what I was indicating is that you took, as you stand before me, the wards are your clients. What I am then told is that you took funds that would have been client funds and somehow took them into your possession to redistribute. Your argument may be that you did it for other reasons.
I would like to state the facts behind the assumptions that I took client funds. I did not. Erica told me that she wanted, I was consulting with her as a property manager. I was not her attorney.
Then if that's your position, that's your position. From the court's perspective, it looks different, which is what I was pointing out.
Yes, and you clear, and
And if I want to make an accusation, Ms. Tope, I am not shy. I will clearly make that accusation, and I have not.
you were very clear that it was not an order, it wasn't an opinion, it was words. But I tell you that words have consequences because we are on YouTube.
So does one's actions, Ms.
Yes,
Tope.
yes,
Whether YouTube or not, it doesn't matter. This is a public record.
yes,
And all I am telling you is that the court saw concern.
yes. And I am here to address the concern so that it's on the record as well, so that,
Ms. Tope, no. I have given my admonition at the last hearing. The wards may proceed in whatever fashion they wish. You may proceed in whatever fashion you wish. If I thought you were doing something unethical, I would myself remove you from the case. I have not done that.
No. Right.
So I am done with this issue.
Today. You are done with me today, or?
I am done with that issue.
Okay. Thank you.
Your Honor, this is the first I'm hearing about a property management company that's holding rent payments. I don't know who the property management company is. I don't know what the bank account is. You ordered tenants to produce an accounting. They did that. It's a mess. And my client is the one who's being prejudiced by that. Actions do have consequences, and the consequences of their agent, or the actions by tenant's agent, have consequences. And they didn't have the right to withhold rent payments. That's what they did. These are grounds for default under the lease. The lease should be terminated. and they have to deal with the consequences. Now, if tenants, they may have their own recourse separate from this action. That's their decision. That should not be with my client, and my client shouldn't have to keep fighting over alleged ethical violations.
They did not have a management agent. She consulted with me about my opinion for over 3 years. I had no jurisdiction over the property. It was completely Erica and Aaron's tenancy, and I was not their attorney.
So-
Was I their property manager?
So
Yes.
it's those statements which give the court pause. When you're saying that they consulted with you regarding the property and
Not in my capacity. I was taking writing lessons and she was telling me what was going on, and I gave her some of my advice, but not in a professional or proprietary or
do it
contractual.
that way. Okay. All right.
No, as a friend.
I think Ms. Hope's property company should be a party. She has inserted herself into this litigation. And this went from a simple non-payment of rent and has ballooned because of tenants through their counsel's actions. And it has become a mess.
We filed a circuit court case was filed July 9th, long before this court had jurisdiction. In my first response as their attorney for this court, I asked for an escrow fund to be set up, a trust fund to be set up by the court. And you did that. Anything done before that was not in, there was no money put in any trust fund.
Can I just say, so this, let me just ask this. Counsel, are you
I need to step closer to here. I'm
Are you going, we can get the equipment for
very good.
Counsel, are you going to file a motion to add Ms. Tope and this as a party to this action? I realize I'm asking you on the spot because you're first hearing about it, and I know there would be things to be taken into consideration in doing that.
Obviously, I'd have to discuss with my client. It's something that I would like to avoid. I think the language of the contract is clear that they didn't have the right to withhold payments and that these are grounds for defaults and that the lease should be terminated and there should be an eviction order. But if we have to keep going this back and forth way, we may have to. Especially if it's a third party that's handling the rent funds, then we would have to.
No.
So,
Yes.
were you the property manager for them?
No.
Were you involved in the payment of funds to contractors?
Only in the account that Erica used to withhold her funds. And
What do you mean by that? Who were signatories to that account?
Erica approved all of,
Who were signatories to that account?
I was.
There's our problem.
but not my
Okay,
attorney.
so, no. That's our problem. So, who else was a signatory to that account?
No one else. Me and me alone. And
Okay, Miss,
the money was filed after we filed the circuit court case.
no, it doesn't matter.
And this court.
Doesn't matter. It doesn't matter. It doesn't matter. Do you not see a potential problem with that, Ms. Tarp? That's a yes or no. If you don't, I don't know what to say.
I see that someone could make an issue out of it. But I don't see a legal problem. So when you say a problem,
Let me ask this,
yes.
since you're given that information. And just think about this for a moment.
Okay.
Whether you believe it to be true or not.
Okay.
Plaintiff claims that the tenants cannot withhold rent in this fashion or make repairs and take that off of the rent. Okay? Tenants do that.
Tenants had done that before they claimed that.
Whoa. Tenants do that. Tenants acknowledge they've done that. And that you are the one that did that on their behalf. Why? What happens given that factual scenario, which I don't think is far from the truth based on what I know, if they file a claim not only against the wards, but also as to you?
I'd have to show why it's not appropriate. Mostly because they were notified that rent would be withheld before it was withheld, and they were notified the bank account that,
So if their claim is you can't do it,
well, I guess,
if their claim is you can't do it,
yes.
then that the wards could not do it. But then you were the one that did it on their behalf. Good, bad, or indifferent. You're the one that did it. Don't you really yourself become a necessary party to this action? And that's what I'm saying. If you're a necessary party, Ms. Tope, you can't be the attorney.
Okay. I hear what you're saying.
Mr. and Mrs. Ward, do you understand what the court is indicating? I mean, whether you agree with it or not, it's not my issue. You understand what I'm getting at?
Yes.
And so that I'm clear, and what I was trying to be clear at the last hearing was I did not want a circumstance where Ms. Tope, you're brought in as a party and then your clients are left without representation. It's just an issue of the fairness of all proceedings. It doesn't have to do with whether I like somebody or not, or what position I'm taking. So, Ms. Hope, with that understanding, what are we going to do? I don't want to get so far down the line.
We're off track, for sure.
That what?
We are on this case. We are off track. Get it back centered. I would do whatever's required to be able to deal with the issues at hand and not clog up these proceedings any further.
I don't know what that means.
Well, I'm sorry, that's the only way I can say it.
Your Honor, we're off track due to tenant's agent's conduct by taking actions that were not allowed under the lease in the first place. And this is our third hearing in 3 weeks. And my client is going without any rent payments. He got a partial payment, but he's the one who's being prejudiced by us having to keep coming to court when tenants didn't have a right to do this in the first place. And they have to accept the consequences for their agent's actions.
I was not their agent.
Okay. Then what were you?
I was their friend, and beginning July 9th, I was their attorney in a circuit court case. And they didn't
I
file.
know what, I know what, I'm not gonna go through what you want, what name you want to place on it. Counsel, you know how the terms agent are defined under Michigan law. So the fact that you are somebody's friend does not mean, for the purposes of agency law, that you may not be acting as their agent.
Well, that one would have to prove I was acting as an agent rather than a friend in order to put the official together as an agent.
Ms. Pope, I don't even know how that comes out of your mouth. If you're saying that they had money and repairs that needed to be done on property that they lease, they own the property that they're leasing, and that you, whatever name you want to place on it, take funds as the only signatory to an account of theirs and do things with it, reference the property, pretty much acting as their agent.
I will prepare withdrawal papers and have them sign it. We've talked about this. They're in agreement after this.
Then what? Why don't we start there? Nothing. All right. So you're going to withdraw as counsel?
Yes.
All right. And then, folks, are you in the position right now that you have counsel, or how? No. How much time would it take you folks to get an attorney? What do you think?
I wouldn't know where to start, so I have to look into that.
We typically offer.
Pardon?
You typically suggest.
Well, I don't know. I don't want to bring you back for a hearing and you don't have someone to represent you, but about to go into December, the escrow is gonna have to be paid, so while plaintiff's not getting it, it's gonna have to be paid to the court, and escrow was deposited with the court. If you don't know that, it did get deposited.
Your Honor, I received a handwritten note. I couldn't read it, but that's good to hear that they did follow.
A handwritten,
I received a handwritten note that I don't know what.
Oh, that was my written request because the court was not available Friday after our hearing. That we went to the clerk to pay the escrow, and we were told that we had to get permission from the court.
to pay it in certified funds as opposed to cash, yes.
They paid it, okay.
And I filed that with the court, and I gave you a copy so that you knew what I had done in order to try to get the amount paid. And they also advised me that since this case is really in 14A4, but they can't take funds here at 14A1.
Yes, they can.
Well, they say that it's put into a bond and it's very complicated and,
I don't care how complicated it is, they can take the money.
well, okay,
They don't have to drive up.
I deposited it.
It doesn't matter.
I like
Whatever.
the drive. It was a nice drive.
Okay. So the 4125 is, my point is that is in escrow.
It has been paid.
And that I have the expectation that the 5,500 will be paid within days of December 1st. All right. So I'm going to give the ward's time to find counsel. So I'm going to adjourn this to December 19th. Allow them to get counsel and allow counsel to once obtained to get up to speed on everything that has transpired. All right. So I'll adjourn this matter to December 19th, 2025 at 1 p.m. You said?
Yes.
1 p.m.
Your Honor, my client would like to say a few words.
That's fine. Yes, go ahead.
Thank you. Thank you.
I don't really want much in regard to the substance of the case, but go ahead, sir.
Thank you. Your Honor, so my background is I'm a family man with 6 children. This property is our family's entire retirement. I was adopted, worked my way through school, started a mortgage company in 2003 that's operated for 22 years without a single bad review. I've served on the board of the directors for the Arthritis Foundation and Entrepreneurs Organization. I work with the Congressional Medal of Honor Society. I spent over 10 years coaching and sponsoring at-risk youth for football and baseball, including future Maryland running back Nolan Ray. We have saved our entire life to be able to purchase this property. The tenants have been operating a business on it without paying rent. They've made false statements about me, potential future buyers. They've contacted my land contract seller to try and usurp me and purchase my debt. The land contract seller contacted me to alert me immediately and denied them. They filed a PPO against me. And I haven't even been to my property for close to a year because of how hyper hostile the experiences have been. I won't even take my family there. The PPO was denied immediately. They then sued me in circuit court before my attorney could file for this eviction. This is the 4th hearing over what began as a simple non-payment eviction. They refused to negotiate. Their actions appear intended to harm my family financially. I'm simply trying to protect my property and resolve this properly. Thank you.
Thank you. And to the parties, as soon as the paperwork and the attorneys and the parties are in order, I will expeditiously get this matter to trial, if that's where we have to head. I don't have a problem doing that, but I can't set things when things are in such disarray, quite frankly. The 19th, 2025, 1 PM. Your attorney, once you hire them, will know to file. What they're gonna have to do in this case, they're gonna have to file a substitution. Well, actually not. I'll need an order of withdrawal sent, and then they can file their appearance. All right?
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, folks. Everybody have a great holiday.
Well,
This is. Got one more. Patrick Becker versus Daniel Wolf. In this matter, Wolf, Daniels, neither party appeared. Case dismissed. That's how my day should have gone. You guys take care.